In the last 18 months, 5 prominent opposition leaders were put behind bars. AAP leader and former Deputy Chief Minister of Delhi, Manish Sisodia, Sanjay Singh, Jharkhand Chief Minister Hemant Soren, Kavitha of the BRS, and Delhi Chief Minister Arvind Kejriwal. All of them were arrested by the Enforcement Directorate on charges of money laundering under a stringent act, that is, the Prevention of Money Laundering Act 2002. As of August 2024, 4 out of these 5 leaders are out on bail, with Delhi CM Arvind Kejriwal being the exception. The latest to get bail from the Supreme Court this week was Kavitha. The Apex Court disagreed with Delhi High Court's reading of a crucial exception for women in the PMLA Act. In July, the Delhi High Court had denied her bail. Among other grounds, the judge said Kavitha was a quote-unquote well-educated woman who could not be considered vulnerable, so that exception for women in the PMLA would not apply to her. The Supreme Court overturned it.
They were always tough. We are fighters. We will fight it out legally. We will fight it out politically. They were always tough. By sending us to jail illegally, they have only made BRS and KCR's team unbreakable. Thank you. Jai Telangana, Jai Hind.
But there was another case in the Apex Court this week in which the Supreme Court underlined a key principle of jurisprudence and also a message for the central agencies. Hello and welcome to Simply Put. I am Shubham Chohan. Let's get started. The Supreme Court on Wednesday granted bail to a man called Prem Prakash. Now, Prakash is a close aide of Jharkhand Chief Minister Hemant Soren. He was named as an accused by the Enforcement Directorate in a PMLA case in Jharkhand. While granting him bail, the court said that the principle, which is bail is the rule and jail is the exception, also applies in a PMLA case. This is what a bench of Justices B.R. Gavai and K. Vishwanathan said. All that Section 45 of PMLA mentions is that certain conditions are to be satisfied. The principle that bail is the rule and jail is the exception is only a paraphrasing of Article 21 of the Constitution of India, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Liberty of the individual is always a rule and deprivation is the exception. Deprivation can only be by the procedure established by law, which has to be a valid and reasonable procedure. The court also ruled that the prosecution's case cannot be based either on a statement made by the accused, but in connection with another case or a confession statement by a co-accused. So let's take this piece by piece. For starters, this principle, that is bail is the rule and jail is the exception, is not new. It comes from the Apex Court's own judgment in the state of Rajasthan versus Balchand alias Balia case in 1978. That judgment was based upon several rights that have been guaranteed by the Constitution of India, with Article 21 being the most important one, like the Supreme Court said now. But in PMLA cases, things are slightly different. Section 45 of the PMLA, which deals with bail, says that no court can grant bail for offences under this law, with a few exceptions, like if the accused is under the age of 16 years or if he is a woman or sick. So net-net, the language of the law is such that bail is not the norm, but in fact the exception, and jail is the norm. In PMLA, the burden of proof to prove their innocence, unlike some other laws, lies with the accused, something we see with the stringent UAPA, for example, which is the anti-terror law. The PMLA provision makes it mandatory to hear the public prosecutor in all bail applications, and when the prosecutor opposes bail, the court is required to apply a twin test. There are 2 conditions. First, that there are quote-unquote reasonable grounds for believing that the accused is not guilty of such offence, and second, that he is not likely to commit any offence while on bail. Come to 2022, where the Supreme Court gave a consequential ruling. It upheld the constitutionality of the PMLA. It did not see an issue with the ED's powers to arrest and investigate cases in an expansive manner. The ruling also said that the sharing of the ECIR with the accused, which is basically equal to an FIR for the ED, was not mandatory. That was the Vijay Madan Lal Chaudhary versus Union of India case. But since then, the court has made some notable observations and their interpretation of the law that may offer some relief to the accused. Many legal experts have even welcomed it. In October 2023, the court held that informing the grounds on which a person is arrested in writing would be necessary for the ED. In July 2024, the Apex Court said that the power to arrest under the anti-money laundering law cannot be as per the whims and fancies of an ED officer. More recently, in the case relating to Manish Sisodia, where he was granted bail earlier this month, the court said Manish Sisodia is in custody for 17 months and trial has not yet commenced. This deprives his right to a speedy trial. Right to speedy trial is a sacrosanct right. Bail cannot be opposed, saying that the crime is serious. In matters of liberty, every day counts. Trial courts and high courts ought to have given due weightage to this. Courts have forgotten that bail ought not to be withheld as punishment. Principal bail is the rule and jail an exception. Now it's important to underline one point. Leaders like Kavitha, Manish Sisodia have not been acquitted. The court is yet to get into the merits of the case. But legal experts have welcomed the court's reiteration of this principle. Because remember, central agencies like Enforcement Directorate and CBI have been under the scanner for going after opposition netas. Anil Deshmukh, Sanjay Raut, Sanjay Singh, just to name a few. This report in the Indian Express says since 2014, there has been a fourfold jump in ED cases against politicians, and 95% are from the opposition. A government reply recently in Parliament said a total of 132 money laundering cases have been lodged by the ED under PMLA against sitting and former MPs, MLAs, MLCs and political leaders since 2019. The conviction only in one case. Of the total 132 cases lodged, trials have been completed in only 5 cases, while there has been a conviction only in one case. The lone conviction was in 2020, but the reply does not provide any further details. And it is this huge gap that has raised questions on the quality of the investigation that the agencies are undertaking. For the ED, the message seems to be clear. Blindly going after a political leader, or anyone for that matter, without a watertight case would mean long periods of incarceration without a trial. Something that is being seen already. And surely that wouldn't be in line with the principles of justice. That's all we have for this episode of Simply Put. Do let us know what you think in the comments section below. Thanks for watching.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.